Okay, I'm going to get underway. I trust you can all hear me. I'm not sure if the chat box is not enabled, so I apologize for that. Just letting you know that today's information session is just general advice. It's not related to individual advice. As we know, relationships and family relationships come in all shapes and sizes. So there's no one fit for all. So it's a very general overview of eligibility. As we know, immigration law and policy change frequently. So before proceeding with an application, you should seek professional advice about your individual circumstances. So just to let you know a little about, and also the session is being recorded. So we don't share checklists unless you become a client or assess your eligibility, but we will certainly send you a recording of this so that you can review it later. Just a little bit about myself. I've been a registered migration agent now for over 25 years. I used to be the former national president and director of our professional body, the Migration Institute of Australia. So I've been working in this space for a long time. Migration Downunder is a company that I founded, and we've got a team of specialists that are all in-house registered migrations agents and migration support team. So today's agenda, we're going to be talking about the partners, the visa overview and options for partners. And we're also going to be looking at parents and an overview and options for their eligibility and process for both partner and parents. And there will be options for Q&A at the end for any questions that you may have. So just going through the types of partner and spouse visas. Sorry, I'm just looking at here. Oh, I have got a couple of questions there. Okay. Okay, yes, we can hear you. Great. Chat is disabled. Oh, okay. All right. Thank you. The Q&A box seems to be open. Sorry, I should have had my IT do that. I'm not quite sure how to update that chat box, but if you'd like to put anything in the Q&A and let me know if you are interested in parents. I know there are a couple, so I will briefly go over partners if there are not too many people that are looking at the partners. So partners, they come in all shapes and sizes. You've got de facto spouse or married spouse. Australia recognises same-sex relationships, whether that be de facto or married. So there is no discrimination between any relationship. All you need to be able to show is that you're in a genuine, continuing and committed relationship with your Australian partner, or if you're the Australian citizen or permanent resident, that you're in a committed relationship with your temporary or your partner who's a temporary resident or perhaps offshore. So the subclass 309 and the 820 are both the same types of visas. One is just for those that are applying offshore outside of Australia, and the 820 is for those that are already here in Australia on another type of visa. Perhaps you've entered in on a visitor visa, you've entered in on a maybe a working holiday, or you're on a graduate visa, a student visa, a working visa. As long as you're on a valid substantive visa, then you can apply onshore for an 820. You're actually applying for a combined temporary and permanent class. So 820, 801 is combined, and the 309, 100 is combined. If the relationship is less than 2 years, then you'll get the provisional visa, either the 309 or the 820. And then in 2 years from lodgement, you'll be eligible to apply for the permanent visa. The subclass 300 is for those that are not in a de facto or married relationship, but they have the intention of getting married within the validity of the visa grant. And that's the subclass 300, that's a prospective marriage visa. And that's often a good one where the Australian citizen or permanent resident is here in Australia and can't go and reside in the country where their partner is. Maybe it's work, maybe it's a visa problem, whatever reason, and they're have a genuine desire to get married, then the subclass 300 is a good visa and good option because it allows you to come out here with full work rights and make certain you are compatible and you do wish to pursue that marriage. And that visa is currently being granted for 12 months. During COVID, it was 15, but they've gone back to the 12 months. So once you are granted a 300 and you do get married, that's when you then lodge the 820 visa. The processing times are varying. Offshore sometimes are a little quicker than onshore, depending on the country that you're residing. A lot of countries within Southeast Asia are quite quick, whereas the applications coming out of countries such as India, New Delhi, their processing is quite lengthy. Onshore processing can be lengthy, but the good thing about the fact that once you're onshore and either you, the applicant, or your partner is granted a bridging visa, then once that bridging visa comes into effect, you will have full work rights on that visa. So sometimes the processing of an onshore partner visa, even though it's taking a long time, you still have access to our health care scheme, Medicare, and you have full work rights. And if you do need to travel overseas, there is the ability to do so if you apply for a bridging visa B. So obviously, if you can get onshore, then that's the best option if you're wanting to be with your partner straight away. De facto relationship, a lot of people get confused with what is actually a de facto relationship. It's no different than a marriage, that you do have to show that you are living together in a committed relationship. You're more than just girlfriend, boyfriend scenario. You've combined your household, you share your financial responsibilities. It doesn't mean you have to have a joint shared bank account, but you do need to show that you share your financial responsibilities. You do need to be recognized as being in a de facto relationship by family and friends, and not just casual boyfriend and girlfriend, and you need to be an exclusive relationship. The only difference between a marriage and a de facto relationship is a marriage certificate. All other documentation required is exactly the same. You can register your de facto relationship, but you don't have to if you have resided together and can provide evidence that you've lived together for 12 months or more. And if you can do that, then there is no requirement to register your relationship. The only reason for registration of a relationship is to overcome that 12-month cohabitation requirement. Whereas if you are married, there is also no requirement to show any particular period of length of relationship. And that's, but you do need to show that you've got a genuine committed relationship. Often people get confused on how to evidence that, how to verify that, and that is broken down into 4 different pillars, which I'll briefly go over. You also have to be over 18 years old, and you've got to pass the character criteria. Sometimes if you are married offshore and the law in that country permits a marriage less than 18 years old, then it may be permitted, but generally speaking, most countries have lifted that to 18 years of age. So the same with the sponsor, you've got to be over 18. You haven't previously sponsored someone within the last 5 years. If you have, there can be exemptions, but on very limited circumstances. And again, the sponsor does also need to meet the character requirements, and that is the protection of the visa applicant to make certain that they're fully aware of any past history that the sponsor may have and hasn't disclosed. What they're looking at for there is domestic violence, assault, and any criminal acts against children and minors. It's a 2-step process. The partner visa, if your relationship has been less than 3 years at the time of applying, which means that you can't show that you've been living together in a de facto or married relationship for 3 years at the time of application, or if you've got a child together, a biological child together, it's 2 years, then they will assess eligibility to show that you are in a genuine relationship. They'll grant that provisional visa, either 309 if you're offshore or the 820 if you're onshore. And then what will happen is that they will reassess to see that you are still in that genuine relationship 2 years from when you have applied. So sometimes if the first stage is taking a lot longer, then the second stage you don't have to wait as long until you're eligible to do that second step. There's no charges for that step, no government fee charges for that second step. It is confirming that you are still in that genuine relationship, and that you can provide evidence and updated evidence to support it, and also that you need to be able to you actually need to apply. You can't just automatically assume that the government is going to check. There is another application that you've got to complete and submit so that the department can see that you're still in that relationship, and upload all your evidence. So the 4 pillars, they look at the nature of household, how you share that household, who else is living in that house. Are you renting? Are you living with parents? Do you own the property? Maybe your Australian partner, spouse owns that property. How do you share the responsibility of everyday household duties, financial payment of bills, etc. Mutual commitment, it may be a child, it may be simple as that you've got future commitments together. It might be an overseas trip to perhaps meet the visa applicant's family. It might be that you're going to buy a car, or you're getting a dog. There's all sorts of different ways that you can show that mutual commitment. And also it might be in the way that you've already committed to certain things in your life. It might be that you've got joint household insurance together, health insurance together. You have declared yourself to other government bodies as being in a de facto or married relationship. The other final 2 of those 4 pillars is financial aspects. Touched on that briefly in regards to showing joint financial commitments. You might share costs of everyday living, your groceries. It might be that you've purchased something together for the household. It might be that you've, I don't know, you're paying off a holiday that you're going to be going in the future. Maybe one of you is listed as a beneficiary on the super, those sort of things. Social aspects are usually the easiest ones. Recognition from family and friends that you are in a genuine married or a de facto relationship. They recognise that you live together, that you get invited to social gatherings that family and friends are invited to. So that is very much it as a sort of in a nutshell for the partners. Registration, some of the pitfalls, the registration and marriage certificate alone not going to guarantee you a visa approval. So many people mistakenly think that, oh, we're married, we don't need to do anything to evidence our relationship. And again, not being able to evidence that you are in a genuine and committed relationship. I know sometimes it's difficult, and sometimes it's actually more difficult for those that are in a genuine relationship. And that's where we help try and unpick some of the things that you can show. It might be just really simple things that you haven't even thought of. And if you're doing the subclass 300 visa, you do need to marry within that period. But a pitfall is if you're not on the 300, you marry within a very short period of knowing each other, and they're not living together. Again, that's also a bit of a red flag, although the government do recognise arranged marriages and cultural customs where there are arranged marriages and they don't necessarily live together because the Australian sponsor is here working and obviously needs to continue to working so that they can support their new partner, their new spouse. So there are exemptions to that rule. So let's talk about parent visas. Sorry, there will be questions at the end if anyone had anything from partners, but just from the feedback I've got, it appears that a lot of you are here for the parent visa options. Parent visas, I think the biggest concern is the lengthy processing time frame, and that's mainly due to the demand outweighs the supply. The government also cap the number of applications that they grant each year. And as our skilled migrants and our migration population in general continues to grow, it's only natural that they want to have their parents here with them. It might be because they have got children themselves and they want their parents to enjoy spending time and being here with their grandchildren. It might be to assist with looking after children. It might be that there is no one else left in the home country and they want to be here with their children. There's lots of different options for parents. Again, the main factor is possibly the processing and also the cost as well. Just let's look at the standard visitor visa. Many people are not aware. If you are the parent of an Australian citizen or permanent resident, then you can actually get a 3-year multiple re-entry visa that allows you to come and stay in Australia for up to 12 months at any one time. You can only stay for 12 months in any 18-month period. So that is a really good way to come out where maybe your child or your child's partner has just had a baby and you want to spend longer than that standard 3 months, then you can get a 12-month or 3-year multiple re-entry with a stay of up to 12 months. You can't extend beyond that 12 months because there is a condition on the visa that you can't go, you can't spend more time than 12 months in an 18-month period. Really quick processing, and it's a really good one to come out and have. Obviously, it doesn't allow work rights. It doesn't allow access to Medicare unless you're from a country that has those reciprocal rights. And then the other temporary visa is the sponsored 870 parent visa. Processing with that is quite quick at the moment, and that is an option for parents that want to come out here and be with their children that perhaps either don't meet the balance of family or they've got an offshore permanent parent visa pending, and because the time frame of the processing is ballooning right out, the 870 is a good one to come here and be onshore whilst you're waiting for that parent visa. Now, there's a few things with the 870 that people are not aware of. You do actually have to have an approved sponsor to begin with. So generally that is your child or your child's spouse can be the sponsor. They need to be earning a certain income. It can be combined income with both the child and their spouse if they do have a spouse. And the sponsorship, once that's approved, you can then lodge the visa application. You must be offshore to lodge that visa application, and that usually it takes about another 2 months. So it's probably about 2 months for the sponsorship, sometimes quicker, another 2 months for the visa. So in total, you're waiting sort of 4 months. If you're offshore and applying and you get that and you're waiting and you've got a visitor visa to come in whilst that you're waiting for that, that's fine. You can do that. That's no problem at all. You can apply for up to 3 years or 5 years. I know on the website it says you can stay up to 10 years. There is a catch there that many people are unaware of, and we're not quite sure why and what the logic is behind it. Yes, you can stay for 10 years on the 870. However, you've got to be offshore and you've got to remain offshore for a set period of time before you can apply for that second 5-year visa. So that's a real problem and really annoying, especially if you've set yourselves up here in that 5 years and maybe you're waiting for the permanent parent visa and it hasn't come through yet. You've got to somehow sort of extend your time. So that's the only downfall of that, but it is a good one to have in the interim if either you don't meet the balance of family or you're waiting for the offshore permanent parent visa. The other thing was the 870 visa, that you won't have any work rights and you don't have access to Medicare, even those with reciprocal Medicare, such as people from the UK. You can't actually get Medicare on this particular visa, and you do have to have private health insurance to cover you for that period. Now, the permanent parent visa, there is a couple of different options we'll go through. and the parent processing is very lengthy, and you do have to meet the balance of family. And if you've got 3 children, 2 out of those 3 must reside in Australia, and 2 out of those 3 must be either permanent residents or Australian citizens, or a combination. If one's a citizen, one's a permanent resident. So we'll go through a little bit more about that eligibility on another slide, but just looking at the contributory versus the non-contributory, I often get asked about this. To be able to lodge an application here in Australia to access what's referred to as a bridging visa, to allow you to remain in Australia for the duration of that processing, you must be, or if you're doing a combined application with your spouse, then one of you must be 67 years of age or older to be able to lodge an application whilst in Australia and access that bridging visa. So generally speaking, there is 2 types of visas you can lodge onshore. It's the subclass 804, which is the non-contributory, or there's the subclass 864, which is the contributory. The non-contributory is where you're paying the standard fee, and the government website is saying 30 years. I don't think it will take that long, but you will be waiting 15 to 20 years. I've got clients that are nudging 15 at the moment. We're hoping that they are going to come through soon on the non-contributory. The contributory was always a good option for those that wanted a visa quickly, because you paid a lot more money, not up front, but at the time they're ready to grant the visa, that you would get your visa a lot quicker. When it first started, it was a couple of months, and then it ballooned out to 12 months, then 18 months, and then it was 3 years for a long time, and now you're waiting. The visas that I've had 7 years ago, they're taking 7 years, but if you are to lodge now, the prediction is about 12 years. And again, it's because the demand outweighs the supply, and it's all dependent on whether they continue to restrict that number or whether they extend it. From COVID, they doubled the number of parent visas to try and help with the backlog, and they've continued that with that number, but they haven't increased it in the last couple of years. From memory, it's about 8,500 parent visas, so you can imagine that's not very many in a year. And you can also be in Australia to lodge the offshore 143 as well. However, you won't get a bridging visa if you're doing the 143 onshore, because you'd be under 67, and you wouldn't, if you're over 67, you wouldn't do a 143, but it does allow you to lodge it if you're in Australia, the 143. You just don't get a bridging visa. The only thing it doesn't allow you to lodge that whilst you're the holder of an 870 visa. That's the main restriction with the 870, is that you cannot lodge and apply for permanent visa whilst the holder of an 870. You can apply for a permanent parent visa and then apply for the 870. That's no problem at all, but you can't do it the other way around. There is obviously the offshore non-contributory as well, but I don't even bother with that. Why would you lodge an application from overseas and not ever thinking that you're going to get that visa if it's taking 20 years? There is also the temporary parent visa, the 173, or which there's also an 8. I can't think of the number at the moment, but there's an equivalent onshore. Again, I don't really recommend the temporary. It used to be great when the contributory visa used to take only a year, and it gave people time to save up that second visa application charge. So they split the big charge, which currently is 43,600 per person, and it's remained that for last 10 years, I think. And they used to be, you can pay 2/3 up front and then 1/3 within 2 years, and then you reapply for the permanent visa. But now that it's taking such a long time, I don't recommend that, because you've also got to continue to meet the health criteria. And that's one of the concerns with the processing timeframes taking such a long time, the permanent parent visas, is meeting the health criteria at the time of decision, because none of us can guarantee how our health is going to look, sort of one day to the next, let alone in sort of 10, 15 years. So that's always a little bit of a gamble. And how they do the permanent parent visas for both contributory and non-contributory, you lodge the application. It's all paper-based. They all get lodged in Perth in Western Australia. And they just check that you've got a valid application. They'll give you the bridging visa if you are eligible for that. You'll pay that first application fee, but then nothing happens with that application until they're looking at it to assess the eligibility, that you meet the balance of family, that you meet the health and character. So at the moment, the non-contributory and the contributory, they're taking about 3 to 5 years to get to you to then assess eligibility. And at that time, you've got to meet the health requirements. And if you do, then you'll go on that queue for that visa, whether it be the contributory and non-contributory. And when you are on the queue, especially for the non-contributory, then you can sort of breathe a sigh of relief, because some people go, well, you know what, I'm 70 now, or I'm 85. I may never get permanent residency, or maybe it's your parent, you're thinking they may not get permanent residency. But if they're on the queue, you've got that sense of relief knowing that they're going to be able to remain here in Australia on that bridging visa forever and time. Worst case scenario, if they don't meet the health requirements, there are other options there of getting medical treatment visas, or appealing the decision, even though you might not have any, even though you're not going to succeed in the appeal. It then that takes another few years, so it allows you to continue to remain here. You then go for ministerial appeal and on compassionate and compelling circumstances, because once you get the media involved, no one's going to throw a parent out who has been here in Australia for a long, long time. So basic requirements, you've got to the applicant must be a parent of an Australian citizen or permanent resident who has spent at least 2 years living in Australia. There are some exemptions to that rule if they are a settled Australian, and if it's less than 2 years, then there's ways of getting around that. You need to meet the balance of family for the permanent parent visa. There's no waivers for that. You must be in good health and meet the requirements for the health at time of going on the queue, and then again at the time of decision. You can't be the holder of a subclass 870 visa, which I mentioned, and you have an assurance of support at time of decision. And that's generally the child of the parent being your assurance of support, showing that they have got the means and capability of supporting you financially if required. So I think we touched on why the processing times are so long, just because they're capped each year. Changes in planning levels, it's always a hot topic. Demand outweighs the supply. It's a hot topic because of our aging population and the burden on the health anyway in general, and so bringing more in sort of adds to that. But then from a humanitarian point of view, oh gosh, you can't deny someone to have their parents here, and likewise you can't deny parents to want to be here with their children and possibly grandchildren as well. And it fluctuates due to the visa grants, refusals, withdrawals, sadly people passing away, then the numbers reduce in that. But sorry, look, I raced through that at the end. It's quite a lot to fit in with both parents and partners, and perhaps we should do something that is separated next time to give everyone a bit more time. But happy to take any questions in the Q&A. I've got one here that says, I read on the immigration website that you cannot apply for a subclass 103 parent if you've already applied for a holder of an 870. Is this correct? Yes, that is correct. You can't, if you have applied or if you hold an 870 temporary visa, you can't apply for any permanent parent visa. So that's why you need to apply for the permanent parent visa first, and then apply for the 870 visa. So it's difficult if you're not quite 67 and you're thinking, well, actually, I want to be over here now. And that's when possibly you look at the 870 and you just do a 3-year visa, so that when you do turn 67, you could go offshore, come back into Australia on another type of visa, like an ETA or a visitor visa, and lodge it. There's a good question. Someone's asked, does 870 have a health requirement? Yes, it does. Just like the permanent parent, it requires to meet the health. There is no waiver for the health requirement for the 870, even though you've got to hold health insurance. You do need to still pass the medical for that. And basically what they're looking at is that there's no severe ailments, that they're not going to require for the duration of that visa any major surgery, transplants, that you're not going to be reliant on community services like aged care facilities, I should say, and making certain that they are actually able to look after themselves and not reliant on any government support. So yes, there is a health requirement. So there's no health waiver for either the 870 provisional or the permanent parent. So happy to take any more questions. Otherwise, I'd like to think that I have covered off that quite quickly. Oh, there's a question. Can you clarify if there's any age criteria to apply for a 103? No, there's no age requirements for any offshore permanent parent visas. So again, I wouldn't bother with the 103 because it is a non-contributory. You'd do the 143 where it is quicker processing, but you wouldn't do the offshore non-contributory because it takes too long. You'd be waiting 20 years. What's the point? And before then, you'd be able to lodge something onshore. So there's no age restriction from lodging an offshore permanent parent visa, but if you want to lodge a permanent parent visa whilst in Australia to access that onshore bridging visa A to allow you to remain in Australia for the duration of the processing, then yes, one of the applicants, either the husband or the wife, does need to be 67 at the time you apply. Someone's asked, my dad is here on a visitor visa. Can I apply for permanent parent visa onshore? You can if they meet the eligibility requirements that I just went through. So as long as they're 67, as long as they meet the balance of family, as long as there's no restriction on their current visitor visa, yes. And then they can access the bridging visa A. One more question. This one's for partner visas. Do we need to attach photo evidence of hanging out together with a statement of witnesses? Yes, you do need to show that part of the social aspects of relationship is providing photographic evidence, not just the two of you together, but with family and friends, along with, as you say, statements of people that know you on a intimate basis. Well, they see you on a regular basis, I should say. All right. Well, thank you very much for attending today's information session on parents and partners. If you do have any more questions or you have anything you want to ask further, then don't hesitate to reach out to us. Our details are there on the screen now. We do have regular webinars. We sometimes do them just for partners or just for parents. We've got a skilled migration one coming up next month. But if you want to know further information about your individual circumstances, then please go online through our website and book a consultation. But thank you very much for your time, and I trust you found this information session informative and helpful for your needs. Have a good afternoon or day, whichever part of the world you're currently in. Thank you very much for joining me. Goodbye.